The Supreme Court just dropped a bombshell ruling that every single gun owner in America needs to hear about right now. And if you carry a gun, or you're thinking about getting your concealed carry permit, this changes everything. Quick question before we continue. Are you subscribed to this channel yet? Because what I am about to break down could literally be the difference between carrying legally and accidentally becoming a criminal. Hit that subscribe button right now. Seriously, do it before you forget. Okay, let us get into this. On June 23rd, 2022, the United States Supreme Court handed down one of the most important gun rulings in American history. The case was called New York State Rifle and Pistol Association versus Bruen. The vote was 6-3, and the decision sent shockwaves through courthouses, police departments, and gun stores all across America. We are still feeling those shockwaves today. So what exactly happened? Let me break this down in plain English so there is zero confusion. Before this ruling, there were two types of states when it came to concealed carry. You had what are called shall-issue states. In those states, if you pass a background check and meet the basic requirements, the government shall issue you a carry permit. They do not get to say no just because they feel like it. Then you had what are called may-issue states. These are the ones that caused all the problems. In a may-issue state, the government could look at your application and say, we do not think you have a good enough reason to carry a gun, even if you were perfectly legal, even if you had zero criminal history. They could just deny you. They had total power over your right to protect yourself. Now, here's the crazy part. States like New York had a requirement called proper cause. This meant that if you wanted a concealed carry permit, you had to prove to the government that you had a specific special reason to need one. Just saying, I want to protect myself and my family was not good enough for them. Not good enough. Think about that for a second. You are a law-abiding citizen. You have never broken the law, but the government gets to decide whether your reason for wanting self-defense is valid enough. That was the system that existed for decades in some of the most populated states in America. New York, California, Hawaii, Maryland, Massachusetts, New Jersey, and Washington, D.C. were the biggest offenders. These were the strictest may-issue jurisdictions in the country. Getting a carry permit in these places was nearly impossible for the average person. In some counties in California, the denial rate was over 90%. In New York City, regular citizens almost never got approved. In Hawaii, permits were so rare that practically nobody had one. Here's what most people get wrong about this ruling. They think it only affected New York. No, that is not even close to the full picture. When the Supreme Court struck down New York's proper cause requirement, they did not just change one state's law, they changed the rules for the entire country. The court said clearly and loudly that the Second Amendment protects your right to carry a firearm in public for self-defense. Not just in your home, out in public. And the government cannot make you jump through impossible hoops to exercise that right. This one ruling created a massive chain reaction. Because when you knock out the legal foundation that these restrictive states were standing on, their entire concealed carry systems start to collapse. Every state that had a proper cause or good cause or special need requirement suddenly found their laws were unconstitutional, just like that. Now, let me explain why the number 31 matters here, because this is the part that really blew my mind when I dug into the research. Before the Bruen ruling, the Supreme Court itself noted that only about 43 states were what you would call genuine shall-issue states. The rest were either may-issue or had no real system at all. But here is where the wave effect comes in. The Bruen ruling did not just fix the 7 most restrictive states. It opened up legal challenges and momentum in dozens of other states too. After Bruen, we saw state after state being challenged in court. We saw new legislation getting pushed through. We saw governors and attorneys general forced to change how they handled permits. Between the states that were directly forced to change and the states that changed their laws in response to the new legal landscape, more than 30 states saw real, tangible changes in how concealed carry works for their residents. That is, tens of millions of gun owners who now have more freedom than they did before. If you are finding this helpful, imagine what you will learn in my next video. I'm covering the 5 specific words you should say when a police officer asks if you are carrying. Those words could protect you legally. Subscribe right now so you do not miss that one. All right, let us keep going, because this is where it gets really interesting. So now you understand what the ruling did. But let me tell you about the new test the Supreme Court created, because this affects every single gun law going forward, not just concealed carry. Before Bruen, courts used what is called a balancing test to decide gun cases. They would weigh the government's interest against your Second Amendment rights and figure out which one was more important. Gun control advocates love this test, because governments can almost always come up with a reason why restricting guns is in the public interest. The Supreme Court threw that test in the trash. The new Bruen test says this: If the government wants to restrict your Second Amendment rights, they have to prove that the restriction is consistent with the historical tradition of firearms regulation in America. In other words, they have to find a similar law from around the time the Second Amendment was written, back in 1791 or shortly after. If they cannot find historical evidence that a similar restriction existed, the modern law is unconstitutional. Period. This is a massive, massive shift. And here's why it matters for you right now. Think about all the gun laws on the books today. Red flag laws, magazine capacity limits, restrictions on carrying in certain public places, assault weapons bans. All of these laws are now being challenged in courts using the new Bruen standard. And some of them are not surviving. Federal courts all across the country are being forced to answer this question. Does this specific gun law have a historical equivalent from the founding era? And for many modern laws, the honest answer is no. Now, quick legal note here, and this is important. Everything I'm telling you in this video is educational information only. It is not legal advice. Gun laws are incredibly specific to your state, your county, and even your city. Before you make any decisions about carrying a firearm, please consult with a licensed attorney who specializes in firearms law in your state. What is legal in Texas may be very different from what is legal in California, even after Bruen. Okay, back to the breakdown. Let us talk about what this means for you practically, because information is only useful if you know how to apply it. First thing, if you live in a state that used to be may issue, go check your state's current concealed carry laws right now. Do not assume you know what the rules are based on what they were 2 or 3 years ago. Things have changed fast. California, for example, went from one of the hardest states to get a carry permit into a state where the legal landscape is actively shifting. Same story in New Jersey and Maryland. Second, if you have been denied a concealed carry permit in the past, you may have grounds to reapply under the new legal standard. The old, we do not think you have a good enough reason. Denials are gone. If you meet the objective requirements in your state, they have to issue you that permit. Third, pay attention to sensitive places laws. After Bruen, many states rushed to pass new laws banning guns in so-called sensitive places. Hospitals, schools, government buildings, parks, bars. In some states, the list of sensitive places became so long that carrying anywhere in a city became nearly impossible. Some of those laws are being challenged right now. Knowing where you legally can and cannot carry in your state is absolutely critical. Getting this wrong is how good people end up with felony charges. Hey, real quick. 73% of people watching this right now are not subscribed. Do not be in that group. Join the 50,000 gun owners who get these legal updates first. Click subscribe right now and you will always know when something important drops. Let us talk about the real-world impact, because I want to make this feel real for you, not just legal theory. Here's a hypothetical example to explain this clearly. Imagine you are a woman living in a major city in a state that used to be may issue. You work late shifts, you commute through areas that are not always safe. You applied for a carry permit 3 years ago. You were denied. The reason? The issuing authority decided that your concerns about your personal safety were not specific enough to qualify as proper cause. That was legal back then. Under the old system, you had almost no recourse. Now imagine the same scenario after Bruen. You apply for your permit, you pass your background check, you complete your safety training. And the government cannot deny you just because they think your reason for wanting a gun is not good enough. Your right to protect yourself is recognized as a constitutional right, not a privilege that the government gets to hand out selectively. That is what this ruling actually means for real people. It is not just a legal technicality, it is a fundamental shift in how the government treats your right to self-defense. Now let us talk about what is still being fought over. Because the Bruen ruling did not solve everything, not even close. Multiple states have passed what gun rights advocates are calling workaround laws. These states acknowledged that they could no longer require you to show a special need to carry. But they responded by creating massive lists of places where carry is prohibited. New York passed a law essentially banning guns from almost every public space you can think of. Times Square, restaurants, subways, movie theaters. Basically, the entire state became a sensitive zone. That law has been in and out of courts ever since. Parts of it have been struck down. Other parts are still being argued. California did something similar. Maryland, New Jersey. These states are fighting back hard against the Bruen ruling, using every legal tool they have available. And here is the part nobody is really talking about. This legal battle is far from over. The Bruen ruling was a huge victory for gun rights. But every single month, new cases are being decided in federal courts that either expand or limit the practical impact of Bruen. Some judges are applying the Bruen standard strictly and striking down gun laws left and right. Other judges are finding ways to work around Bruen by claiming historical equivalence. This is a legal battle that is going to be playing out in courts for years, maybe decades. This is exactly why staying informed is not optional. It is not something you can put off. The law in your state could change because of a court ruling you never even heard of. And if you are carrying under rules that just changed, you could find yourself in serious legal trouble without even knowing it. This information is moving fast. Laws are changing sometimes faster than the news can keep up with. Subscribe to this channel right now, because my next video is going to cover exactly what you need to do before the next big legal deadline hits in 2026. You do not want to miss that. Let us wrap this up with the key takeaways you need to remember. The Bruen ruling was the biggest Second Amendment victory in over a decade. The Supreme Court said clearly that you have a constitutional right to carry a firearm in public for self-defense. The government cannot require you to prove a special need just to exercise that right. May-issue states across the country were forced to change. And the new Bruen test, requiring a historical justification for gun laws, is reshaping how courts look at firearm regulations from coast to coast. But the fight is not over. States are pushing back. Courts are still deciding cases. And the rules in your state may be very different from the rules in the state next door. So here is what I need you to do right now. Number 1, subscribe to this channel so you never miss a critical update. Number 2, go look up the current concealed carry laws in your specific state tonight. Number 3, if you carry a firearm, talk to a local firearms attorney to make sure everything you are doing is fully legal under the current rules. Look, I put hours of research into every single video on this channel, so you do not have to dig through hundreds of legal documents yourself. All I ask is that you hit that subscribe button so we can keep doing this together. Because the best defense against an unexpected law change is knowing about it before it happens. And remember, this video is for educational purposes only. It is not legal advice. Every situation is different. Consult a licensed attorney in your state for guidance specific to your circumstances. Stay safe, stay legal, and I will see you in the next one.